Good afternoon, and welcome to the School of Law. For those of you whom I haven't met, my name is Bo Rutledge, and I have the honor of serving as the Dean of the Law School. I want to thank you for your attendance today at this very special Sibley lecture. I want to welcome Dan's wife, Sally, daughter, Amy, his friends, the Honorable Steve Jones, Rebecca White, and others. Here at the Law School, we are committed to redefining what it means to be a great national public institution, one that offers a world-class, hands-on, purpose-driven educational experience with a pioneering commitment to accessibility and affordability. That's captured in our motto, prepare, connect, lead. Named lectures like today's embody and discharge that mission. It offers you, and in particular our students, the chance to connect with great legal thinkers before you embark on a career of professional leadership. This lecture, the Sibley Lecture, was established in 1964 by the trustees of the Charles Loredens Foundation. It honored the late John Sibley, a 1911 graduate of this law school who was the embodiment of a legal leader. In the intervening 60 years, the Sibley Lecture has attracted outstanding leaders from around the nation and the world to speak on a topic of their choosing. The first was delivered by Yale Law School's Professor Myers McDougall almost exactly 60 years ago, entitled Jurisprudence for a Free Society. Since then, this lecture has hosted countless influential speakers, Supreme Court justices, members of the judiciary, leaders in the academy, public servants. Today, we hear from one of our own, Dan Coenen, university professor, Meigs Distinguished Teaching Professor, the Caldwell Chair in Constitutional Law. His talk, Mystery, History, and the Dormant Commerce Clause Rule. Introducing Professor Coenen is 1995 alumna Julia Houston. Ms. Houston has a long and storied career, which you can read about online. But for your purposes, I want you to know three things about her. Number one, she took contracts from Professor Coenen. Number two, she took constitutional law from Professor Coenen. Notice the recognition in the room, Dan. And number three, she served as the research assistant for Professor Coenen, an experience that she'll share with you. And I would be remiss if I did not thank Julia for creating a scholarship bearing Dan's name, and I'm pleased to welcome Jaden Ware, the inaugural Coenen Scholar. Now, will you join me in a great bulldog welcome for Julia Houston, who will introduce this year's Sibley Lecturer.
So good afternoon, everyone. It is so great to be here at the law school. As you can hear, I'm a Georgia law grad and bulldog through and through, and so it's really special to have the opportunity to do this. As I started to prepare for this introduction, I realized that if I highlighted all of Professor Coenen's vast accomplishments, I could easily make this introduction longer than the lecture itself. So I'm going to limit myself to some of his most significant. As you heard from Dean Rutledge, the Sibley Lecture series holds a special place here at Georgia Law. And in every way, as I think you'll agree, Professor Coenen is a perfect fit for this honor. After completing law school at Cornell, Professor Coenen held two prestigious court clerkships, first for Judge Hainsworth on the Fourth Circuit Court of Appeals, and then for Justice Blackmun on the U.S. Supreme Court. And after several years in private practice in North Carolina, much to our good fortune, he joined the faculty here at the law school in 1987, teaching, as you know, in the areas of contracts and constitutional law. As Dean Rutledge mentioned, in 2005, he was awarded the title of University Professor, which I don't know if you know, but is given to no more than one faculty member at the university each year, and who, in addition to fulfilling their academic responsibilities, serve as change agents and have had a significant impact on the university. His scholarship is prolific. He's written 3 books, one actually with his son, Michael, who's a professor at Seton Hall Law School, and he's working on a 4th. And by my count, he's published more than 15 law review articles. But beyond his written work, his greatest legacy might be the thousands of students he's taught and mentored who have gone on to practice law with the same integrity and passion that he exemplifies. He's made an indelible mark as a teacher on generations of Georgia law grads, and he's been recognized for that repeatedly. He's received the university's highest honor for excellence in teaching, been designated as a Meigs Distinguished Teaching Professor, been selected by his students on multiple occasions as a recipient of what's now known as the Ellington Award for Excellence in Teaching. He's been chosen by 13 graduating classes to serve as an honorary marshal at their commencement. He's truly beloved by his students, including myself. So, as a former student of Professor Coenen, more years ago than I'd like to acknowledge, I can personally attest to the depth of his knowledge, the clarity of his teaching, and most importantly, his unwavering commitment to his students. I'm going to have you indulge me as I tell a quick story. It's one of the moments from law school that I've never forgotten, and I think you'll see why. So, as you heard, I was in the section that had Professor Coenen for contracts, and I have to admit that that was the class where I most dreaded getting called on. Some of the content, it was a little hard for me to follow as a first year, and I had this fear, which turned out to be well-founded, that when I did get called on, it might not go so well. So when the day finally came, I don't remember the line of questioning, but I do remember that about 3 questions into it, Professor Coenen was bounding up the stairs to my row, and he scooted behind the chairs, and he picked up my textbook and looked at the footnote we were talking about, and he exclaimed, "I'm checking to see whether Ms. Houston has a different casebook than I do." Every word of this is true, every word. And so obviously you can see I was not doing a very good job answering his questions about the case. And so I debated crawling under the table and sinking through the floor, but instead we all had a good laugh, including me. I somehow got myself back together, and we got through the case, and then thankfully it became somebody else's turn. And guess what? The sun still came up the next day. My law career was not over. And I remember it to this day, not because I was embarrassed, but because it reminds me that the lessons that Professor Coenen taught me were more important than the substance of contracts or constitutional law. He reminded me always to keep a sense of humor and how powerful a tool it can be in making a point effectively or navigating a challenging situation. He taught me to be resilient and flexible and to maintain a positive attitude. He gave me a drive to learn, to excel, and to stick with things even when they're hard. He showed me what it looks like to love what you do and the people that you do it with. And most importantly, he reinforced for me the importance of caring for those around you, the way that he does for his family, his students, the law school, and the Athens community. He shared with me once recently that one of the only downsides he could think of being a law professor is that when your students go on about their careers, you lose touch, and maybe you don't get to see the impact that you truly had. And so, Professor Coenen, I hope that gives you a small glimpse into the immense impact that you've had on me and so many others like me. So with that, it's truly a pleasure for me to turn it over to today's Sibley lecturer, Professor Dan T. Coenen.
To say that I'm grateful for that introduction is the understatement of the century. I can't tell you how meaningful it is for me to hear those words from one of my former students, and in particular, a student who I admire and genuinely love as much as I do Julia. I've attended many Sibley lectures over many years. They've been delivered by Supreme Court justices like Earl Warren, Antonin Scalia, and Ruth Bader Ginsburg, as well as academic titans in the law, like Richard Posner, Martha Nussbaum, and John Hart Ely. All of this got me thinking about someone named John Stockdale. In 1992, Admiral Stockdale was the running mate of the third-party presidential candidate Ross Perot. And in his opening statement at the vice presidential debate, Stockdale began by asking these questions. Who am I, and what am I doing here? Well, whatever the answer to those questions might be for me, here we go. The title of my talk is Mystery, History, and the Dormant Commerce Clause Rule. This talk has its roots in a project I've been working on for the past 3 years, or maybe the past 33 years, depending on how you count. Anyway, here's the manuscript of my book. And here's what I'd like to share with you about it today. Let's start with basics. First, what on earth is the Dormant Commerce Clause Rule? It is a judicially enforceable constitutional principle that stems from the idea that the 50 states are all part of one single economic common market. In other words, this rule authorizes judges to strike down state laws that undermine the operation of America's common market. A classic case is City of Philadelphia v. New Jersey. That case arose when New Jersey prohibited the disposal in New Jersey of solid waste generated in other states. The Supreme Court found that the law was unconstitutional even though it had not been preempted by any congressional legislation. The court reasoned that this law violated the Dormant Commerce Clause national common market principle because New Jersey had erected a barrier right at the state line to the importation of out-of-state solid waste, or if you want to prefer to think of things this way, the exportation of in-state waste disposal services. Many of you are now yawning. Politely asking only to yourselves, who on earth cares about that? Well, one reason to care is that the Supreme Court has struck down hundreds of state regulatory and taxing laws based on this principle. And it has done so for an important reason. Put simply, the Dormant Commerce Clause Rule has to do with making the United States genuinely united. And united in a way that was of the highest importance to our nation's founders. Justice Oliver Wendell Holmes elaborated on this point more than a century ago in writing these words. I do not think the United States would come to an end if the Supreme Court lost its power to declare an act of Congress void. But I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. For one in my place sees how often a local policy prevails with those who are not not trained to national views, and how often action is taken that embodies what the Commerce Clause was meant to end. So what is the mystery about the Dormant Commerce Clause Rule? The mystery has to do with whether this rule is legitimate. That is, whether the Dormant Commerce Clause Rule really is in the Constitution. Is it? Over many years, Justice Scalia argued that the Dormant Commerce Clause Rule is not in the Constitution, and Justice Thomas continues to make the same claim today. Their argument begins with the text of the Commerce Clause, which states, and there it is, I now quote it, "The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes." According to the argument of Justice Scalia and Justice Thomas, this language only gives power to Congress, and it doesn't say anything at all about taking power away from the states, including the power to regulate interstate commerce. For this reason, they assert, if the power given to Congress to regulate interstate commerce is not exercised by Congress, that is, if the Commerce Clause remains in a dormant, that is, unexercised state, then no restriction on state authority comes into play. And that is true no matter how much a state's action messes with the movement of commerce across state lines. And so it follows, for analysts like Justices Scalia and Thomas, that cases like City of Philadelphia v. New Jersey, and hundreds of other cases too, reflect a misapplication of the Constitution by the Supreme Court. So far, the position of Justices Scalia and Thomas has not won out. In fact, for nearly 200 years, most recently in an opinion for 7 justices written by Justice Alito in a case called Tennessee Wine and Spirits Retailers Association v. Thomas, the court has said that the Commerce Clause in its dormant state does require the court to strike down acts of individual states that abridge this principle that the states are part of a unitary common market. One justification for this principle builds on the historical reality that unifying the nation with regard to commercial matters was a central goal, if not the central goal, of the framers and ratifiers, who were clearly trying to get rid of the sort of self-serving and isolationist state laws that had caused serious interstate conflicts during the years of the Articles of Confederation. In addition, as Justice Holmes suggested, this principle seems to make pretty good sense because states inevitably will be tempted to act selfishly by removing themselves from shared national problems, just like New Jersey tried to do by blocking the importation into it of solid waste from other states. Analysts like Justice Scalia and Justice Thomas, in response, say something like this: we don't care about some argument about what makes maybe good sense, or about generalized notions about the framers' goals. What we care about is the constitutional text. And the constitutional text, they insist, was meant to deal with the problem of interstate trade wars only by giving power to Congress, not by giving power to the courts to act on their own to strike down state laws. So who's right? The answer I offer in this extremely long book goes like this. Let us assume, along with Justices Scalia and Thomas, that the traditional justification for the Dormant Commerce Clause rule, based on the framers and ratifiers' background purposes, is too, let us say, loosey-goosey to override the dictates of the constitutional text. Let us also assume that these justices' method of interpreting the constitutional text, that is, based on its originally understood public meaning, is the right way to interpret our founding charter. In short, let's agree to play in Justice Scalia's and Justice Thomas's methodological sandbox. But then, let's dig into that sandbox using those justices' own methodological tools to try to discover what we can about the originalist case, both for and against the Dormant Commerce Clause rule. In other words, even if we accept the text and history-centered interpretive methodology of Justices Scalia and Thomas, we must still answer the entirely separate question of what is the proper application of that methodology to this particular interpretive question. And my conclusion is that the relevant evidence reveals, indeed, in my view, reveals quite clearly, that a proper application of Justice Scalia's and Justice Thomas's interpretive methodology leads to exactly the opposite conclusion than the one they reached. In other words, contrary to the claim they make, the Dormant Commerce Clause rule, in my view, is entirely legitimate based on the Constitution's original public meaning. Now, why is that? Well, good luck to me in trying to summarize a 300-page book in 20 to 30 minutes. All I can do is give you a Cliff's Notes version of my reasoning, and that's what I'll try to do now. Let's start with what seems to be the strongest argument in favor of the Scalia-Thomas position, namely that the Commerce Clause, on its very face, only grants power to Congress, so that it obviously does not allow the courts, acting totally on their own, to block the states from engaging in their own regulation of interstate and foreign commerce. The problem with this argument is that the historical evidence, particularly as set forth in essay number 32 of the Federalist Papers, written by Alexander Hamilton, indicates that there was an understanding at the time of the Constitution's adoption that some grants of federal legislative power are inherently exclusive. In other words, that grants of certain powers to Congress without anything more carry along with them a prohibition on a state's ability to exercise those same powers. And as even critics of the Dormant Commerce Clause rule recognize, if a federal power, a federal congressional power, is exclusive, the whole point of its exclusiveness is to exclude the states from doing certain things. So now another question arises. Was the grant of the power to regulate interstate commerce one of those powers that was understood at the time of the founding to be inherently exclusive to Congress so that the states cannot exercise that same power, and the courts are duty-bound to enforce this constitutional limit on state action. As it turns out, and I invite you to read the whole thing, and it's just one chapter, there are 3 separate textual arguments that support the conclusion that the commerce power is exclusive. In the interest of time, I will focus only on one. The argument was set forth first by Chief Justice Marshall in 1824 in the landmark case of Gibbons versus Ogden. Here's what he wrote. It has been contended by counsel that the word to regulate implies in its nature full power over the thing to be regulated, so that it excludes necessarily the action of all others that would perform the same operation on the same thing. It produces a uniform whole, which is as much disturbed and deranged by changing what the regulating power designs to leave untouched as that on which it has operated. In other words, Chief Justice Marshall summarized the argument of counsel as interpreting the word regulate to give Congress full authority over interstate commerce, thus prohibiting the states from imposing their own inhibitions or limitations on that commerce in any way that Congress had chosen not to do. Having set forth this argument of the lawyers in the case, Chief Justice Marshall added this: there is great force in this argument, and the court is not satisfied that it has been refuted. The key point for our purposes is that this reasoning of Chief Justice Marshall is based squarely on the text of the Commerce Clause. That is, on the meaning of the word regulate as used in that clause. Justices Scalia and Thomas might say in response something like this: the idea that states can't regulate what the federal government is given the power to regulate is silly, maybe even stupid, because we all know that the federal government and the state governments often both regulate the same activity, like in passing their own drug laws. But Chief Justice Marshall anticipated this argument. As he explained later on in his opinion in Gibbons, just because the federal government and the state governments often restrict the same activity doesn't mean that when they do so, they are exercising the same power. In other words, the general regulatory power of the states, which is sometimes called the police power, and the separate federal power to regulate interstate commerce sometimes overlap. But that doesn't mean that the state police power and the federal commerce power are the same power, or that these two different powers overlap completely so that the states can do whatever the federal Congress can do. More specifically, when a state, like in the New Jersey solid waste case, does something that specifically targets and dramatically disrupts the flow of interstate commerce, a court must characterize the state's action as a regulation of interstate commerce and not as an exercise of the state's police power. And once the court characterizes what the state has done as a regulation of interstate commerce, the state's law necessarily becomes unconstitutional because the power to regulate interstate commerce belongs exclusively to Congress, and therefore that power cannot be exercised by the states. Here's another point that I think is often overlooked. For me, Chief Justice Marshall's textual analysis, which may seem complicated, at least demonstrates that the words of the Commerce Clause were, at the time of the founding, ambiguous as to whether Congress's power over interstate commerce is exclusive. And if the words of the Commerce Clause are ambiguous on this score, then we must turn to the historical evidence from the time of the framing to determine how that ambiguity is properly resolved. In other words, to resolve the mystery of whether the Dormant Commerce Clause rule is legitimate, we must look at the history of the founding period. What does that history teach us? In arguing against the legitimacy of the Dormant Commerce Clause rule, Justice Scalia once wrote, quote, "The historical record provides no grounds for reading the Commerce Clause to be other than an authorization for Congress to act." In a sense, the goal of my book is to show that this statement is inaccurate. Indeed, extremely inaccurate. In fact, snooze alert, my book sets forth 10 separate arguments as to why the historical record does provide grounds for reading the Commerce Clause just the way the Marshall Court read it. That is, as giving to Congress a commerce power that, because it is exclusive, does not belong concurrently to the states. So here is the good news for you. I am not going to go through each of my 10 arguments. Here instead is just a small sampling of my history-based analysis. To begin with, the framers and ratifiers wanted passionately to get rid of just the sort of short-sighted, self-interested, union-undermining state laws that the Dormant Commerce Clause now prohibits. Indeed, they saw rising trade wars among the states as threatening the very survival of the then still fragile and only recently established union. Moreover, if the framers and ratifiers' goal was to get rid of these union-threatening state laws, the best way to get rid of them was by prohibiting them right out of the gate, which in essence is what Justice Alito said in the Tennessee wine and spirits case. The response to this point from analysts like Justice Scalia and Justice Thomas is that the intended remedy for rising state trade wars was to give to Congress, not the courts, the power to preempt problematic state laws. But this argument has a question big in quality, because the very question we're addressing is whether the text of the Commerce Clause, including in particular its use of the word regulate, is properly interpreted to give Congress an inherently exclusive congressional power, as opposed to a power shared with the states. To repeat, if Congress's commerce power is exclusive, just as Chief Justice Marshall's textual analysis in Gibbons indicates it is, then the courts have no choice but to protect that exclusivity by striking down state laws that are rightly characterized as an exercise of the power to regulate interstate or foreign commerce. Another thing is that the framers and the ratifiers openly spoke about the need to create a new constitution because it would assign to Congress all those governmental powers that the states had proven themselves, and this is the key word, incompetent to exercise, which powers obviously included the power to regulate foreign and interstate commerce. And if the states were seen as being incompetent to exercise that power, it seems pretty commonsensical to conclude that the framers and ratifiers would not have wanted to leave them with that power as opposed to assigning that power, which they were incompetent to exercise, exclusively to Congress. Now, on top of these background or purpose-driven justifications for the Dormant Commerce Clause Rule, there are, hold on to your hats, 7 historical episodes that took place during the founding era that indicate that the makers of the Constitution understood the commerce power to belong exclusively to Congress. Here's one. Before the Constitutional Convention took place, concerns about the ineptitude of the states in handling the Union's commercial affairs had grown and grown to the point that 2 separate blue ribbon committees of the Congress then operating under the Articles of Confederation recommended, first in 1785 and then again in 1786, that the Articles of Confederation themselves should be amended to vest the federal government with the power to regulate foreign and interstate commerce. There was extremely widespread support for these proposals. Indeed, from all appearances, the only reason they never became a law was that amending the Articles of Confederation, according to the Article's own terms, required the all but impossible feat of securing the unanimous agreement of all 13 state legislatures. So why does that matter? It matters because under the Articles of Confederation, all of the powers given to the federal Congress were held exclusively by the federal Congress and thus denied to the states. And so, if the Articles of Confederation had been amended to give the pre-Constitution Congress a new power to regulate foreign and interstate commerce, that power would have been held exclusively by the federal government. Perhaps you are beginning to see the point. If the nation's leaders in 1785 and 1786 were rallying around the idea of changing the Articles of Confederation to give the old Congress, operating under those old articles, an exclusive power to regulate interstate commerce, it would be super weird to conclude that they didn't mean to give the new Congress, established by the new Constitution, a similarly exclusive commerce power. After all, the whole point of adopting the new Constitution was to expand and enhance the federal government's power at the expense of the states, not the other way around. To all of this, and much more, because I've skipped over 6 other historical arguments, Justices Scalia and Thomas might raise one last meta objection. They might say, well, Admiral Stockdale, all you've offered is circumstantial evidence for your assertion that the commerce power was understood to be exclusive. In other words, you haven't yet offered any direct evidence that the leaders of the founding period were actually thinking and saying that the text of the Commerce Clause would establish an exclusive federal power. As it turns out, however, just such direct evidence does exist, and indeed, it does exist in abundance. Continuing with my Cliff's Notes approach, I will say simply that statements indicating a recognition of the exclusivity of the commerce power came from James Madison, Alexander Hamilton, Gouverneur Morris, James Wilson, John Rutledge, Robert Livingston, Oliver Ellsworth, and other key political leaders of the Federalist side, as well as major anti-Federalist leaders like James Monroe of Virginia and Luther Martin of Maryland. In addition, many essay writers of the time, who again represented both the Federalist and anti-Federalist viewpoints, likewise signaled their understanding that the commerce power would belong exclusively to Congress and thus not to the states. Having made this point, I want to pause to recognize with great appreciation the heavy lifting that was done by many student researchers, some of whom are sitting in this room, beginning with my fellow traveler, Dean Monister, who has led the charge. These people helped me comb through the historical records to find out what leaders of the time actually had to say on this topic. In a nutshell, what those records show is that a wide variety of speakers and writers indicated that they understood the Constitution to take the commerce power away from the states, while also indicating, as best I can tell at this point in my research, that not one single person openly espoused the contrary view. That is, that under the Constitution, the commerce power would belong concurrently to Congress and the states. As James Madison, the father of the Constitution, wrote many years later, the object of the convention was, among other things, to take from the states the important power over commerce. You want to hear more about the history? I don't think so. So let me turn now to a different and broader point. Let me share with you some of what I was thinking about or came to think about in a general way with regard to engaging in textualist and originalist analysis as I pursued this very textualist and very originalist project. To begin with, there exist some standard critiques of the original public meaning methodology of interpretation, that it is backward-looking in a way that allows long-gone white men who lived in circumstances very different from those of our own time to make key decisions about the rules that govern our lives. that this methodology invites cherry picking of historical evidence by lawyers and judges, including lawyers and judges who are not skilled historians. That largely for these reasons, the originalist methodology is subject to manipulation. And even that this methodology is on a collision course with itself, if, as some have argued, the framers and ratifiers themselves did not mean to embrace a locked-in-time meaning of the open-ended phrases included in a constitution designed to endure for ages to come. Now, of course, there are very serious arguments on the other side made by proponents of the original public meaning methodology of interpretation, beginning with the core point that their methodology creates at least some objective basis for constitutional interpretation, as opposed to allowing unelected judges, so it is said, to read the Constitution however they might want. There are also arguments that this sort of interpretive methodology comports best with what the framers and ratifiers themselves had in mind, and also that it's a natural outgrowth of having adopted a written constitution, and in particular a written constitution that specifically authorizes changing its terms over time by way of an amendment process. But today I'm not going to talk about any of that. Instead, I want to share a few thoughts that may be a little bit new about how to go about using the original public meaning methodology in a properly careful and accurate way. I want to emphasize that my goal in offering these thoughts is not to criticize anybody. My goal is simply to offer some food for thought. First, what are modern originalists to do with what we might call the original originalists? Consider John Marshall. Some originalists might say that Marshall is an untrustworthy source for modern originalist meaning seekers because he just sought to expand federal power every chance he got. In my view, this is a highly oversimplified and misleading caricature. Indeed, in Gibbons versus Ogden itself, Marshall wrote these words: "The enlightened patriots who framed our Constitution and the people who adopted it must be understood to have employed words in their natural sense." All of which sounds pretty textualist and pretty originalist to me. On top of that, people tend to forget, or they never learn, that John Marshall was himself an on-the-ground ratifier of the Constitution, indeed, a quite active delegate to the Virginia Ratification Convention. And other members of the court, his court, were also near to the scene. Justice William Johnson, for example, learned to be a lawyer from Charles Cotesworth Pinckney of Charleston, who had served as a delegate to the Constitutional Convention. And Justice Bushrod Washington, who, like Marshall, had served as a delegate to the Virginia Ratification Convention, was a favorite nephew of his uncle, George Washington, who, among other things, had actually presided at the Constitutional Convention. So here's the point. To the extent that these close-in-time observers of the Constitution-making process later reflected on the Constitution's properly understood meaning, including as to the exclusivity of the congressional commerce power, perhaps some special attention should be paid to what those close-in-time observers had to say. Another takeaway from my journey in writing this book is more general. Put simply, I kept discovering and then rediscovering and then rediscovering again and again how difficult it is to put the originalist methodology to work, at least in some contexts. Professor Ringhand recently was kind enough to read this gargantuan tome. And afterwards, she told me that she had always suspected that Justice Scalia's original public meaning-based challenge to the Dormant Commerce Clause Rule might not hold up to close scrutiny. Being a highly sensible person, however, Professor Ringhand did not choose to follow up on that thought by spending multiple years of her life writing a book on this subject. And neither did anybody else except me. One reason why others might have hesitated to take up the task was hinted at by Justice Scalia in an article he published 35 years ago. He wrote this: "It is often exceedingly difficult to plumb the original understanding of an ancient text, and if properly done, that task requires the consideration of an enormous mass of material, as well as immersing oneself in the political and intellectual atmosphere of the time." My own lived experience in writing this book left me with no doubt that this observation is right on the money. At the same time, what I increasingly came to sense as my own work on this book unfolded is that those analysts who have challenged the Dormant Commerce Clause Rule on original public meaning grounds, and this would include Justice Scalia, had not yet gone far enough in doing the exceedingly difficult work in looking at the enormous mass of text and history-related material that bears on the question. And why might that be? I think really the main reason is that life is short. And busy people, beginning with busy Supreme Court justices, simply don't have the time to do something like this. It's just the way it is. Also related to Justice Scalia's reflection on the difficulty of doing hardcore originalist work is a bit of a worry that I've had as I've been wrapping up this project. The worry is that any normal human being encountering such a long and elaborate defense of the Dormant Commerce Clause Rule might well react by saying something like this: "Well, Coenen, if you had to put together a 300-page manuscript to refute the originalist challenge to the Dormant Commerce Clause Rule, which, by the way, has been advanced by the world's most prominent practitioners of the originalist methodology, there must be quite a bit to be said in favor of their argument. I get the instinctive reaction, but I want to resist it by saying this. It's the very depth of the dive into the historical materials that has convinced me that the textualist and originalist case in support of the Dormant Commerce Clause Rule is extremely strong. And it simply takes a lot of explaining, drawing on a lot of evidence, and responding to a lot of counterarguments to show why that is the case. Maybe you have a suspicion that I am wrong. Just like Professor Ringhand had a suspicion in the opposite direction many years ago. If so, and I mean this sincerely, more power to you. I encourage you to push forward in exploring the Constitution's original public meaning as to the existence or non-existence of the Dormant Commerce Clause Rule. And if it might be helpful, I brought an extra copy of my book. You're free to come and get it. So you can take in and challenge and improve on or disprove my arguments, which is what we academics are in the business of doing. As I close, I want to share two thoughts that really don't have much to do with either the Dormant Commerce Clause Rule or with originalist analysis. Although these two thoughts are thoughts that have come to me as I've reflected on the process of writing this book. The first observation I offer is for all of you who till the soil of the law, whether as lawyers or judges or scholars. Writing this book helped me to appreciate more than before some very elementary principles of doing good legal work. That first impressions can be deceiving. That a lawyer's well-timed use of a skeptical eye can yield surprising and helpful results. That gathering all of the important evidence, whether legal evidence or factual evidence or both, is often a task far more demanding than initially expected. And that digging deeper often can lead the lawyer to discover more and different nuggets of argument-bolstering gold than were the target of the lawyer's initial quest. For us, or at least for me, this all takes us back to Admiral Stockdale, whose words, "What am I doing here?" touch on the subject of modesty. What we might call or think of in this context as the good lawyer's embrace of a sort of professional modesty, built on recognizing one's own limitations. It is this sort of professional modesty, after all, that causes really good lawyers not to act too fast, too casually, or too unthinkingly. That is, that causes them to be more focused more thorough, and more deliberate in doing their work than, especially given the press of time, they otherwise might be. The second thought I want to offer is one I offer to those of you who are my students. Of course, if you found yourself in one of my classes, you know it is a professional hazard of being my student that from time to time you have to endure my advice-giving ruminations of this sort. Anyway, if you are a student, here's my advice. You too need to think about professional modesty, but not in a way that makes you terrified or petrified at the soon-to-be-realized prospect of actually practicing law. Instead, you should put your professional modesty in a broader frame. In particular, as you move forward toward being a lawyer, you can and should carry with you a self-confidence. You should do this both because you are extremely bright and also because you've already learned an enormous amount, in large part by way of your training at this remarkable law school. But my own life in the law, including in writing this book, causes me to urge you at the same time also to do something else as you move into and through the practice of law. In part because you are bearing in mind your own professional modesty. Always keep looking for chances in handling the tasks that come your way to put to work that part of yourself that is skeptical and inquisitive and creative and intellectually alive. My experience in watching lawyers over many years has taught me that adopting this mindset will help you provide the greatest value in serving your clients. But it will also, and no less importantly, provide great value to you by helping you to grow both as a lawyer and as a person. The overarching point is pretty well captured in advice that came my way from an incredible lawyer who was my own mentor during my own earliest years of practicing law. From time to time, he would tell me this: "It is a good and wonderful thing to be learned, but it is far better and far wiser to still be learning." I'm deeply grateful to everyone who is here today. And I'm especially grateful to the broader University of Georgia family, of which I've been blessed and honored to be a part over the past 37 years. Thank you.